Chairwoman Decker,
Here.
Member Connors,
Present.
Executive Director Miguel Nunez,
Present.
Legal Counsel Raymond Carchia.
Present.
Thank you. So today's agenda is pretty long. So our first item is for the committee to discuss and vote upon attached election legislation submitted by the Board of Elections to the General Assembly. And the committee in a future date will also present a report of the recommendations to the full board at our next meeting next week.
Yes.
Thank you. All right. Miguel, do you want to walk us through it?
So regarding this first piece of legislation here, this legislation was proposed by Board Member Jack Boney at the last board meeting, and there was some discussion regarding the legislation about potential ways to make some modifications to it in order to present it to the full board on Tuesday. And I believe we do have some members of the public here. We had written testimony submitted by Disability Rights, the ACLU, and Common Cause. And I believe Common Cause and Disability Rights is here today as well as Board Member Jack Boney as well. So I don't know if the chair would like to first take public testimony before the subcommittee discusses the legislation.
I think that would be helpful since we
Fine.
did some discussion before. So we will take your testimony. Come on in. You can both come in at the same time. Yes. We have enough chairs and microphones. Hi, John. Hi, Kate. You can start off whoever you want.
Am I?
You're on, yep.
It's not the button up, button down, like if there's General Assembly. Yeah, thank you for inviting us to testify. I didn't plan to testify beyond the letter that we sent yesterday. I have seen both Disability Rights Rhode Island's letter, the ACLU's letter, as well as spoken to Bob Marshall from who represents as a client.
The DD Council,
Yeah, sorry.
the Developmental Disabilities Council.
Yeah, the Developmental Disabilities Council of Rhode Island, who's expressed some concerns about the draft and, concur in their concerns as well. So that's all I have, but I'm happy to answer questions about our letter if you have questions about our letter.
Do you have any questions?
Well, I actually do.
Okay.
So is your concern focused on the agent language? Are your concern focused more on the language, or is it focused on the policy behind what the legislation seeks?
So I think our concerns are twofold. One, and it's both of those things. One is the broader policy, right? We're concerned that the board not support a policy that would prevent voters who need and are seeking legitimate assistance in voting a mail ballot from receiving that. We don't want to criminalize that. Additionally, the way that this attempts to do that or effectuate whatever change it's trying to effectuate, I think lacks clarity. So we pointed out one example, which is it doesn't define an agent. And I think we all know, like, agent can be defined a lot of different ways. I could be your agent simply because you say, could you do this thing for me? And that, I think, speaks more broadly just to the perils of how difficult it is to regulate this behavior because, you may be a registered member of a political party and that could be considered sort of an agent of that party. And I know that's not the intent here. And we respect the intent, which is we want to protect the voter. But doing so is just really, really challenging.
So, I guess what I'd be thinking is, so do you see any potential modifications that we could impose that would achieve what we're trying to achieve here? And I don't want to speak for the commissioner who presented this because I was in favor of it the last time, frankly, because I think it gives the voter the same privacy rights that they have when they walk into the election booth. And I think that's part of the sort of impetus for this. And I'm just trying to get to a point where we can give the voter that same right to privacy, if you will, or that same protection, if you will. I know there are some voters that need assistance with the ballot. And I share your concern on assistance with the ballot. My experience tells me that sometimes that assistance with the ballot goes beyond assisting the voter and it becomes directing the voter. And I think that's a distinction, and maybe that doesn't make sense, but that's a distinction in my mind, that I have a distinction between assisting the voter in marking a ballot, in choosing a candidate, in choosing whether or not to vote. The issue I have is in directing the voter to vote for A.
Yeah, and as I think we said at the conclusion of our letter, and I know the ACLU mentioned it as well, it seems like the existing statute governing mail ballots essentially criminalizes what you're describing already, right? It's just not doing it, it's not enumerating
Right.
the types of people who might be trying to manipulate the voter. It's just saying anyone trying to manipulate the voter.
Okay.
Thank you.
Thank you.
Kate, hi.
Thank you.
Thank you for coming.
Am I on?
Yes, just move the microphone closer to you.
No.
Yeah.
Okay. Is that better?
Yep.
I too was not expecting to testify. I'm happy to be here. I think our letter stands on its own. Our concern is we cautioned against setting up a system where some voters with disabilities have the right to choose the assistant that they want and others do not. So we're just trying to flag sort of unintended consequences. And we do understand the instinct for guardrails in this area and share John's observation that it's challenging.
Can I ask a question? Because you mentioned the ACLU, and the ACLU isn't here, but Kate, I'm wondering, and we just asked modifications from Common Cause, but because the ACLU letter also makes note that some of the issues may be mitigated by an amendment suggested by the Secretary of State's office. I don't know if we have that amendment here.
I didn't see that.
Yeah. So I know that they've shared language with like sort of proposed like mitigated language language that may mitigate this. So one, I'm wondering if somebody from Secretary of State would be willing to share some of that language. Because I'm wondering, Kate, to your point, if some of that would also cover what you shared.
I believe that you should hear it straight from the Secretary of State's office.
Mhm.
My understanding is that their proposal was around restricting anyone from providing unwanted
Mhm.
assistance to anyone.
Yep.
So I would urge you to hear from them on that.
Great, thank you.
A question for both of you. Don't you think that the question of an agent could be clarified by regulation?
Yeah, absolutely. And I know like at the federal level, the FEC in various regulations has defined agent in different contexts. I would note though, as you know better than anybody, this board isn't subject to the APA. So this could pass. You could never promulgate regulations, as has been true on, in a couple different areas. And so yes, you could, but maybe you wouldn't. would
Well,
be
we
my
could
problem.
add language that says that the board shall promulgate regulations. I mean,
You could. That wouldn't exactly address
right, I
John's
understand that,
point.
because we might
but-
not define agent, not regulation.
I mean, it would almost be
Oh.
unenforceable without a definition of agent. I mean, you couldn't prosecute somebody without that kind of a definition. But that's one question I had, whether there's a need to pull the bill that was submitted by Mr. Giacoboni, or it hasn't been presented as a bill yet, but up for consideration by the committee, or if it's something that could be addressed. Each of these very legitimate concerns that are being raised, one, in the context of regulatory action, and two, by a sub-A. It seems that some of these could be addressed that way too. But I mean, I did receive this, I looked it over. I know that this was presented last minute, but I think the issues raised by all three entities are quite legitimate and should be addressed in some fashion.
Lou, do you have any more questions?
Thank you.
Yeah, thank you so much. Do you mind if, would the Secretary of State's
Yeah, I was
office?
gonna
Yes.
ask you.
Thank you, Chairwoman.
Of course. Thank you, Director.
So we agree with Kate and John on the restricting the access to an assistant unless the person who's offering assistance is unwanted. So the very quick language that I've suggested is that no person unless expressly and affirmatively requested by the voter shall be present, interfere, assist, or in any way influence a mail ballot voter during the execution of a mail ballot. And so that just allows for, in the event that a candidate or a political party is the only person that can help a voter, they would be able to do it so long as the voter, really wanted them to help. And we want to make sure that a voter who's voting by mail has the same rights as a voter voting in person. So a voter voting in person can bring whoever they want into the voting booth with them, even if it is a candidate or a political campaign, unless it's their employer or a member of their union, I think. So we just want the male voter to have the same rights as an in-person voter.
But an in-person voter would have the protection even of no influence up to what, 50 feet?
Unwanted, yeah, right. So I think
No,
that-
not unwanted. There can't be any communications within that 50 feet from the door of the building, never mind the polling place.
Right, because in some instances, the way I see it is that in some instances, somebody might not want that. But if they did want it, then I think if a mail ballot voter wants the assistance from a,
No, I understand that, but you were saying that, I thought you were saying that you were trying to equalize the two.
the assistance with helping them vote. So if I wanted to bring a candidate in with me to help me vote my ballot because I needed assistance, and I'm voting in person, I can do that. Because they're not my employer, they're not a member of my union. But if I'm a mail ballot voter and this bill were to pass, then I would not be afforded that ability.
Look, I have.
Please, yeah.
So, and again, I'm not trying to be devil's advocate, but would you agree that assistance inside the polling place is much different than assistance inside someone's home, for the most part? Or could be?
It could be, yes, but in the narrow sense, if I'm at home voting my mail ballot and I'd like a candidate to help me because I need assistance, I would like them to do that. If I bring them into the polling place and up to the voting booth with me because I don't understand something on a ballot, I consider that to be the same. But you're right, there are a whole host of other, poll worker could assist in other ways, but I think in that narrow view of it, I think they're the same.
Again, and my concern is beyond the assistance stage, and I think that's what the legislation tries to address. It's ballot harvesting otherwise. I mean, people go into someone's home with ballots when the ballot gets there and influence their vote, and I think that's what this is trying to stop. But I mean, I'll obviously let Commissioner Giacomoni speak to that if and when he wants to address this, but I think that's the concern, and I know we're walking a fine line here, but I do think that's a legitimate concern.
Agreed. Yeah, we do as well.
And, it wouldn't, I just think it's different from the polling place, but again.
And so can I ask, this is sort of a Ray and Rob possibly question. So, because, and you mentioned at the last meeting too, the possible concern of ballot harvesting. And so there are, correct me if I'm wrong, there's laws today that protect us from this happening. Again, our role is one, to make voting accessible and as efficient as we can, and also protect things like this. But my question is, are there other laws that protect from things like this? And two, with what you're hearing from Rob, do you think that, I think in several of the comments and one of the letters, they talk about this possible language which could mitigate this? So I guess my question is,
Yeah,
do we have things that can stop this?
I mean, we already have provisions that allow for people being charged for election offenses, and those would be felonies. So we already have a statutory framework in place that the prosecutor, the attorney general could rely upon. The question that Mr. DeSimone is raising, the one that Mr. Giacavone has raised, is a little different, which is how do you try to equalize two separate classes of voters? We have what historically was a large class of voters who received tremendous protections from influence within 50 feet of the perimeter of the building, never mind in the polling place. And then we have what used to be a fraction of that for people who could be out of, by their own definition, if some of them are doing mail ballots because they're not even here.
Yeah.
They're at college. The chances of them being influenced unduly is quite low.
Mhm.
So what I believe, and we didn't see this before it was written, but I think what Mr. Giacavone is presenting is the idea that as that class of voters that are no longer receiving these myriad protections by statute, what can be done to try to elevate protections? And I think this is, so I believe there is a deficiency in the statutory framework with respect to how people who are in their home, in their bed, bedridden, being protected from undue influence. The General Assembly started with requiring bipartisan pairs if you're in a nursing home, because there is something implicit about that, about, maybe being more easily influenced. But this would be the next step, I believe, in making sure that there are protections for people who are not at the voting place, the polling place. So I do believe there is a need for it. Whether this statute hits it right between the eyes is an open question. But whether that can be fine-tuned with a sub-A
But we
or
don't
by
have to go survey
regulation.
because it hasn't been submitted yet.
No, I meant if it was submitted.
Oh, got it. Okay.
And because I think that's the question before you, whether you would recommend that it be even introduced.
Yeah.
But if it was introduced and this type of information was provided, as well as what we now have heard, some modifications of this, I believe, are warranted to this bill, if it does make it out of committee.
Just for the record, how are we referencing this particular item?
Thank you, Rob.
It doesn't have an exhibit number.
Mhm.
We don't have to go number.
No,
Right.
call it draft one.
Let's take a look at the agenda, just go
It's-
back to it.
Well, I think we're just referencing it as general legislation, but I meant this particular item, if you're going to vote on it one way or the other.
Didn't we number these? I thought
No, not this
these
one.
aren't, this
I
packet
mean, I
isn't
think
numbered?
That's why I asked.
Okay.
Can we just call it proposal?
Is it the first one?
It's the
Yeah, I mean,
first one
the
in the
copy I
item,
have
yeah.
has a
The
number
first
one
in
on
the
it.
agenda item, yep. So it's right, it's this one. Should be on top of your letters or next to your letters.
Okay. All right, so we'll call it item 1. Right, because it's circled 1 on mine.
Right, and I think you should specify in your vote that it's modifications to Rhode Island General Law 17/2023.
Yeah. I'll make a motion. Do you want to make a motion? And I can second. We get, this
Well,
is,
I don't know if you want to hear from.
oh, yeah, yes, perfect.
Do
Do you want to
say
speak,
anything?
Commissioner? Sit in this one, this one's on. No, the other one. Thank you.
Sorry, thanks. Well, thank you for
Of course,
having
thank
been
you.
on this side.
Thank
of
you
the-
for coming.
of the microphone. Just briefly, first of all, I want to appreciate everybody attending and the feedback from all the parties, whether they agree or not. Part of my, if you recall from the meeting, and I'm not going to repeat everything that I said at the meeting, but briefly, it was, I felt it was a topic that we needed to discuss. So I'm happy that we're having a discussion regardless of modifications, how this turns out. I think it's an important discussion that we have. And as I mentioned in the meeting, I am certainly open to feedback from the public, but more specifically, if committee members have specific language to modify this, I certainly would be open to that. So I don't think, Commissioner Betancourt, you mentioned that there's been no modification submitted. Please don't let that.
Okay.
If you have suggestions,
Yeah.
this is really what this is about, to have a conversation. Just a couple of quick points. I think this comes down to, maybe if I take this up a level, a philosophical. I think we all agree in general. I don't want to speak for everybody, but part of our role is to safeguard the vote. And part of our role is access to the vote. So it's balancing those. Now, some people may see that as 80-20. Some people may see that as 50-50. So I think I'm going to venture a guess and say I'm more on the security side of things. I certainly do not want to diminish anyone's access to the ballot, to their options. I do think one important point here that's kind of underpinning philosophically of why I wanted to discuss this, candidates and campaigns have an inherent conflict of interest to handle these ballots. We are incredibly careful about how we handle the ballots once they get in this door, who sees them, who handles them, who doesn't see them, or we spend a lot of money making sure we process them in a way that people can't see them. Yet before they get out this door, it's like before they get in the door rather, it's like the Wild West. So having candidates, campaigns, and agents, or however we define that, there's an inherent conflict of interest there. So that is one of the things that, for me, is the bottom line for this. I certainly would be willing to define agent. I think there's some, Mr. Marion and I had a discussion, not verbal, but offline, just about some maybe language about agents. I certainly would be open to defining that, because I agree we need to make sure not just anybody. My intention is not just I happen to be registered a party and I help my neighbor, that they get caught up in some felony. If we would want to make the penalty less than a felony, I'd be open to that discussion. So I think those are just some of the things. And finally, I'll just end with this. And certainly maybe we'll have it, whether I think you vote either to support or not support, then it goes to the full board. I'm certainly look forward to further discussion about it. But I do think there is inherent difference in the polling place. A voter is a voter no matter where they are. But voting by mail ballot and voting in the polling place are two very different mechanisms. And the controls are very different on those. And that in some cases, we need to bring them in line. In some cases, we can't, because it's just such a different process. But again, campaigns and candidates have a conflict of interest to handling those ballots. And I think we have examples in the past several years where it's opened us up to potential where not only influence, but ballot tampering. And I've never used the term ballot harvesting publicly, but that wasn't certainly where I was going with this, because then the legislation would be different. But that may be the end point. But with that, I'll just say thank you. Unless there's questions.
Do you have any questions?
I have a motion.
Okay.
I'm going to move to support item 1, which is the mail ballot modification legislation on the condition that we define agent, define immediate family, and move support before the full board. Obviously, it'd be up to the full board to determine whether or not it goes forward.
I'm wondering, as your motion's there, so I have a question. Would you be willing to possibly also make an amendment or some changes around the felony part?
For me,
Yes.
you
You don't have to.
I
This
wouldn't
can
wanna
go to
do
the
that
full
now,
board.
but I would
Okay.
certainly consider it.
Okay.
The only reason I think
Thank
felony is there, and again, I don't want to speak for anybody, but I know there are other sections of the general laws that make voter tampering at least felonies.
Yeah.
But yeah, I'd certainly be willing to include that as part of my motion for discussion, absolutely.
All right, perfect. I have a question. How do we second? Do I second, like if it's just two of us? I've never
yeah.
had this before.
I believe
I'm
you'll
new
have
at
to,
this one.
yes.
And I
Okay.
mean,
So I will second this motion specifically if we are able to have changes or specific information and amendments around agent, immediate family, going to the full board
Absolutely.
and having a discussion at the
I mean,
full
that's the
board.
intent of the motion.
Perfect, thank you. So I second. All in favor?
Aye.
Aye. And so to just to clarify, Ray, is this something that we can work on together of getting some definitions for these items?
Yeah, the normal process, which we didn't do here in this bill, would be to have the staff
Mhm.
and legal counsel discuss this, come up with language. Yep.
And I also should have noted, my God, I'm so sorry. I was going to ask, this might have already passed because we already did the motion, or I can make a motion. Is it possible to take into consideration the changes at the Secretary of State's office?
I'll make a motion
Thank
that
you.
before it gets to.
Oh my God, I'm sorry. I have too many
Before it
notes.
gets to the full board, that both the staff and our legal counsel will look at the modification proposed by the Secretary of State, as well as the, I'm going to call Commissioner Giacopone the sponsor of the bill for our purposes.
Great.
I know you're not the sponsor in the actual legislature, but before us, and for them all to take a look at it.
Thank you.
I'll make that motion
Thank you.
now.
I will second that motion. All in favor?
Aye.
Perfect. Thank you. All right. Thank you. All right, and we can move on to the second item, which is the committee will discuss and vote on campaign finance and election legislation submitted by other individuals and entities to the General Assembly as attached in the legislative summary. Do you want to?
Members of the Legislative Subcommittee, we currently have 18 bills to present to you today. You should have a packet of bills, each paperclip separately. And I am just going to go down in the exact order that they should be in the exact order that I'm going to cover them. Once we're done with one, I believe in past practice, we've voted on each one
Each one.
individually. So we'll just pause so the motion can be made in the second and then for the vote. And then we'll move on to the next one. The first bill you should have in front of you is Senate Bill 0152, which also has a companion bill of House Bill 5276, introduced by Senators Lawson and Basilin. And this act would spell out rules and regulations for the presidential preference primary elections and would also establish rules for ranked choice voting tabulation and results reporting by the Secretary of State. This bill is one of a few ranked choice voting bills. And in the past, the board has not held a position on ranked choice voting, and neither has the staff. I did sit on the committee the Senate committee last legislative session for a majority, to examine and research the different types of election systems and voting by majority. And that was raised. I know that in the years that ranked choice voting has come up, we do know that our equipment does support ranked choice voting. There is potentially a cost associated with it, whereas we would need to acquire some additional software because the vendor doesn't actually produce the software to conduct the ranked choice voting. So in this case, we would need to purchase or develop a piece of software that we would load the results from our system into to actually create the different rankings for the next round and however many rounds it takes to determine who the actual winner is for the ranked choice. So that would be the only input that we would have from the staff, that it would probably take some additional funding to be invested into that aspect of it. But other than that, we didn't have a position on ranked choice voting specifically for the presidential preference primary.
Can I ask, so the software, would that be, because I know there's other pieces of legislation, just ranked choice voting for other things. Is it just one piece of software that would enable us to do ranked choice voting regardless of what type of election it is?
Yes, it's
Okay.
open source software, which we could purchase from, we could contract with a vendor, or the state could build it on its own. That would depend on the funding available, obviously, and the option that the board would want to take with it. But for the overall, the equipment, the actual equipment in our voting system, in our Express Vote DS200s, 850s, they do support a ballot that does contain ranked choice voting on it.
And so, one more question. So regardless of you being the commission, you and the staff still don't have any specific thoughts around this or like positions. This is come up for a few years?
No, it would certainly make running an election much more interesting than it has in the past couple decades. But other than that, it is something that other states such as Maine and Alaska have embraced to some extent for some of their contests. And some actual jurisdictions like Cambridge, Massachusetts have run it for many, many years. There are concerns around other items such as voter education. Where we get more concerned with it is if it's conducted in a primary, perhaps, or even in a general election. And the reason for that is because it does lead to a longer ballot. So what many of these ballots do is the choices move across. So we have a 3-column ballot generally in a general election. We can fit a lot on the front and the back. And these ranked choice voting ballots actually move across on the right. So they move across the 3 columns. So it takes up a lot more of the ballot space. What that means for us logistically is that probably will lead to more 2-page ballots and 3-page ballots, especially in bilingual communities, because bilingual communities generally take up more room to present both languages. And in our experience, multiple card ballots are generally the most challenging elections to run. In communities that have those, because the ballot box fills up faster. That means they have to be addressed more frequently. When me and Bob Raposa went before a Senate commission in 2018, I believe, and we testified that if it were to be done in a general election, for example, then it potentially could mean that we would need to purchase more voting machines because more precincts would have more multiple card ballots. That means that precinct couldn't actually just use one scanner. It would need 2 or maybe 3 scanners in order to compensate for the additional volume of paper going through them. And more paper going through the machines means more possibility there will be a jam or a down machine. So that's where we get into the logistics of executing it at the polling place. But in the presidential preference primary, to my knowledge, it's always been a 1-card ballot back and front, even just the front many times for Republican and Democrat. So I don't think the logistics the hurdles of doing it in the presidential preference primary is that high in comparison to the other elections.
Thank you. Commissioner?
Have we taken a position on this in the past?
No.
It's been before us?
Yeah, this is like, I think the 3rd time,
Mhm.
Did we
Yeah.
take no position on it?
every time.
I'll move to take no position.
Yeah, I'll second. All in favor? Aye. All right.
Aye.
The next bill is Senate Bill 0282, introduced by Senators Morgan and Rogers. This act will require verification of an applicant's date of birth, either a Rhode Island driver's license number or a state identification number on all applications seeking mail ballots and emergency mail ballots. The staff is opposed to simply because of the fact that while it is a policy decision by the General Assembly, ultimately to require this additional verification, the concern that we have is that only applications that are filed online, mail ballot applications that are filed online require a driver's license or a state ID number. And that's similar to if you wanted to register to vote or modify your registration online. The paper application doesn't actually contain that. So this would introduce that requirement on the paper application. And not every voter has a voter ID or a driver's license. So it doesn't address what happens if the voter doesn't have those credentials. How would they apply for a mail ballot? And that would be our concern, since that's not addressed in the legislation the way it's currently written.
Do you have any questions?
No, but I think since, given the fact that I think it's going to limit some voters, I'm
Yeah.
going to move to
Yes.
not support.
Great. And I'll second that motion. All in favor?
Aye.
Aye.
The next bill is Senate Bill 0283. This act would require that only the male voter, their spouse, court-appointed guardian, cohabitant, or any adult person related to the voter by blood or marriage be allowed to physically mail the voted mail ballot. A violation would be a misdemeanor, punishable by imprisonment not to exceed 1 year or a fine to exceed $1,000 or both. This is introduced by Senator Morgan as well. The staff did not have any position on this, as this is a policy decision by the board and the General Assembly.
And Miguel, just for the public, this is 0283, right?
This is
Yep.
0283, correct?
When I read it, it's sort of similar to what we just heard. And so even though it goes above and sort of identifying the individuals, a little bit better than actually the legislation we just saw. When I read this legislation, this is actually why I mentioned the misdemeanor part. And the General Assembly has been doing a decent job at that. And yeah, so I'm wondering, similarly to what we just had, I don't know if we should have a position or,
My suggestion was going to be no position.
Okay.
Let it go forward to the board.
perfect.
I'll move no position on this.
And I'll second. All in favor? Aye.
The next final Senate bill is Senate Bill 0288, introduced by Senators Bell, Lawson, Mack, Ticoian, Gallo, Ruggiero, Lefosas, Ciccione, Phalag, and Urso. This act would provide that for the general officers of the state, no person could be elected to the same general office more than twice, and no person who has held a general office for more than 2 years of a term to which some other person was elected could be elected to the same general office more than once. This act would further provide that a person who was ineligible to be elected governor could not be elected lieutenant governor, and the staff had no position on this.
Do you have any questions?
I mean, I would suggest no position. Although I might be in favor of it if I had to vote on it, but I'd say no position.
Agreed. No comment. Yeah, I think this is something for the General Assembly to decide. So I would second that. All in favor?
Aye.
Now commencing with the House bills. The first House bill is House Bill 5084, a representative by Ackerman and co-sponsored by Falala, Serpa, Newberry, Papaluska, Donovan, and McNamara. This act would add early voting to the 50-foot buffer prohibitions against politicking on election day voting. As you know, the staff potentially was looking into presenting the legislation regarding this to the board ourselves. Then that was rescinded once this legislation was introduced by Representative Ackerman. I know that there were some concerns at the board meeting discussing this 50-foot rule being applied to a city or town hall. And I have reached out to Representative Ackerman, and so has Deputy Director Petracca. We haven't been able to reach her. There might be some language that could be inserted in here that would allow the board to promulgate regulations to clarify this 50-foot rule in certain circumstances at city or town halls, perhaps. But the language has very minimal changes to the statute, and it just establishes that 50-foot rule outside of early voting sites, similar to polling place sites. So we haven't been able to reach her. But we actually do support the overall concept of the 50-foot rule being applied to early voting to some extent as much as possible. I don't know if Ray has something to add to this one here.
Not really. Miguel and I have spoken about this at length. I mean, there will come a time when there's going to be a question as to what else in Chapter 19 would apply to early voting. We have many, many requirements for any place where voting is taking place. By regulation, voting takes place wherever you have a booth. And in those instances, you have to have it roped off, you have to have bipartisan pairs, et cetera, all the things that we have in Chapter 19. At this point, the canvassing authorities don't follow all of those requirements. But I think that's going to be something for this board to chew on, as we have more and more people using that option and what kind of protections will be in place there as applied by Chapter 19.
I do think there needs to be something, so.
Yeah, and I remember the discussion. Yeah.
Maybe we can move to support and have it come before.
Yeah,
I'll move
absolutely.
to support.
Yeah, I'll second. All in favor?
Aye.
Aye.
The next bill is House Bill 5086, Representative Bennett, along with multiple co-sponsors. This joint resolution proposes an amendment to the state constitution, Article 4, Section 1, that will allow 4-year terms of the General Assembly members commencing with the 2028 election. The staff has no position on this bill.
I'll move to take no position as it's a constitutional amendment.
I second that. All in favor?
Aye.
The next bill is House Bill 5137, introduced by Representative Breen and multiple co-sponsors. This act would provide that the State Board of Elections shall verify the citizenship status of all persons on the voter registration list. Again, while it is a policy decision of the General Assembly, if they choose to, and the board, if they choose to enact or support this particular requirement, I only note that the legislation, the way it's currently written, requires the Board of Elections to specifically do certain things to effectuate the statute. And in fact, it's not the Board of Elections that actually does this. It would be more appropriate to have that be the Secretary of State's office, because the Secretary of State actually has the agreements, manages the central voter registration system, and already has those agreements and data agreements with both the Department of Motor Vehicles and the Social Security Administration, for example, and the Department of Health, to transfer, to compare and receive data from these databases. So this would be something that would be more appropriate for the legislation to reference the Secretary of State rather than the Board of Elections, because in essence, the Board of Elections would then have to write regulations directing the Secretary of State to do these things. So it would be more appropriate for the legislation to directly state that the Secretary of State is required to do it. But those are the only comments that the notes that the board has on this legislation.
I mean, even in the explanation, it says that the Board of Elections shall.
Yeah, no, they-
So, I mean, I would say, I don't know how we can support it.
No, I agree.
Certainly.
And I don't think it's the first time that he does this. I think he's introduced this before, the same way.
I mean, I'll move that we don't support it.
I will second that we oppose this legislation.
The next bill is House Bill 5232. This act would authorize early voting for 10 calendar days except the second weekend prior, immediately preceding Election Day, while requiring, as is practical, that all Election Day protections and procedures be afforded to early voters. The staff has no position on this. We just note that early voting is 20 days currently. And early voting is in fact under mail voting, under 1720. So this bill would move it into the election statute, but it would shorten the time frame for early voting to occur from 10 days to 20 days. From 20 days to 10 days, while also bringing some of the same requirements that are required at a polling place to be implemented and enforced at early voting, since it would bring that into the election day category. So those are the only notes that we have, but we have no position on the bill either way.
I'll move that we take no position.
I'll second. All in favor?
Aye.
The next bill is House Bill 5275, introduced by Representative Kislak and multiple co-sponsors. This act would establish an instant runoff form of ranked choice voting limited to General Assembly primary elections with 3 or more candidates. The staff, again, has no position on this. But the only concern, again, is as we move into the potential longer ballot, again, we've never had a multiple page ballot, so my recollection, in a primary, a September primary. However, there does exist the possibility that it could push a primary ballot to a 2-page ballot for the first time. But other than that, the staff has no position on it.
I think since it's ranked choice, we took no position on the other one. Well, I'll move no position on this one.
I'll second. All in favor? Aye. Can I ask a question about that? So when we take no position on things like this, do you still provide testimony sort of explaining
Yes.
why? Okay,
Mhm.
thank you. Just wanted to ask that.
House Bill 5276, this act would establish the ranked choice voting for, that ranked choice voting for Rhode Island presidential preference primaries and provides for new sections on ranked choice voting tabulation and results reporting. This was introduced by Representative Shanley along with multiple co-sponsors. Again, this is another ranked choice voting bill, and the staff has no position on it.
Again, I'll move that we take no position.
I'll second. All in favor?
Aye.
Aye.
The next bill is House Bill H5277, introduced by Representative Corbasi and other sponsors. This act would change the process for nominating candidates for the general election by replacing the political party primary with a primary general election. This new election would allow candidates for all recognized political parties and independents to run against each other on the same ballot, with the top 2 vote getters for each available office qualifying for the general election. And this is a policy decision on how to modify the primary and election process in the state. And the staff doesn't take a position on it.
It sounds like ranked choice voting, just with a different name. It does. I think he should talk to his colleagues. And this is exactly that.
I'll move to take no position.
I will second that. All in favor?
The next bill is House Bill 5382, introduced by Representative Felix and multiple co-sponsors. This act would allow citizens of a city or town who are at least 16 years of age to register to vote and vote in school committee elections in municipalities where school committees are elected entities. The staff doesn't have, as we haven't in the past, a position on this. However, we do note that anytime you establish a ballot that is only eligible for a class of certain people, you have to have a separate ballot style in that polling place, meaning that if someone comes in and they're 16 or 17, they would only be eligible to get the ballot that has school committee on it. And if a voter who is 20, 30, 40 years old is getting a traditional full ballot, they would get the actual full ballot that they would traditionally have gotten in any other day. So that would lead to some logistical hurdles at the polling place to ensure that the proper ballots are given to the proper individuals at the polling place. And our equipment does support that, but it would make the administration of the election day more complex to ensure that the poll workers are trained adequately to give the proper ballot to the proper individual in those polling places.
And I should add to that, in addition to the practical aspects of it, we also have the constitutional provision on having to be 18 years old. And I think that the thinking of the people who are submitting this is that that constitutional requirement is directory. So that, meaning that if you're over 18, you must be allowed to vote, but it doesn't necessarily preclude those who are younger. A canon of construction for judges normally is that when a statute or a constitution is written, is presumed to be mandatory when it uses the word shall, but it shall be rebuttable. If you have some way of interpreting in that language that would suggest that it is only directory. I don't share the view of the author of the legislation that this is directory, but we have really no case on that in this state. So I guess it may be viewed by some as an open question.
Do you want to
I
share
move
that?
not to support it.
That's going to be your
Both
motion?
on a policy level and on a constitutional level.
Got it.
So that's my motion.
Not to support it?
And I'm
Not to,
okay
like
if
to oppose it or to just not to,
well,
to take no position?
I don't
Those are
think
two
we're
different.
gonna oppose it.
Okay.
Because I think we either have been voting either to support or not support, right? At this committee.
Support, no support, or no position.
Mhm.
Okay, yeah, I'm gonna suggest no support.
Okay.
That'd be my motion. And I'm okay if you don't second that.
Yeah, I might not take, I might make my own motion,
I'm
which will
fine
make
with
you
it.
move,
I'm fine with it.
just, if anything, just taking no position on it. Yeah. Okay, so
Is
we're
there-
stalled. So-
Okay, no second.
So then we don't
There's
take
no
a
second.
position because we.
So
we're
we'll,
stuck.
yeah, we'll discuss this one fully at the board meeting. I like that we know where each of us stands on it.
We had the same
We just looked at
discussion
each
a year
other,
ago.
yes.
So the next bill is House Bill 5383, introduced by Representatives place and multiple co-sponsors. This act would require that the primary election date, typically the 8th Tuesday preceding the biennial state election, shall be held on the Wednesday following Labor Day, only if the 8th Tuesday immediately follows Labor Day. Additionally, this act would no longer mandate, but rather will allow local boards to annually conduct a voter registration drive at each high school within the city or town. The staff has no position on this. And I know that in the past, when we've had an issue where the holiday, it does come up where the Labor Day holiday does interfere with the conduct of the primary. Obviously, it's not beneficial for the local boards of canvassers particularly to be running a primary on a Tuesday when the day before was a federal and state holiday. And I know there are some costs associated sometimes with overtime in setting up the polls if they can't get into certain facilities on that, the Saturday or the Friday. So this is something that has come up, but it doesn't impact the Board of Elections in terms of our operations, but it does impact more the local boards of canvassers. But we don't have any position specifically on this piece of legislation.
Yeah, and when I was reading it, my whole thought, because I remember every time we have to vote and certify elections by a certain date, all I kept thinking was if we move it to a Wednesday, does that impact the days? I kept thinking, yes, I see nodding, because I remember that. So we've met an emergency to certify things. So do you?
So I take no position.
No position. Okay. I will.
No position.
I will second.
Aye.
Aye.
The next bill is House Bill 5384. This act would increase from 7 days to 9 days the period of time in which a request for a recount of the votes cast can be made to the Board of Elections. No certificates of election may be issued until the recount is completed. The staff supports this bill. We actually had a conversation. I had a conversation with the sponsor, Rep. Boylan and Knight, and this is directly comes out of what happened in the Barrington election in November, where we had, if you recall, the incident where we had the winner, who was the loser initially. She requested a recount, and then she actually became the winner on the final day for military and overseas, 7 days after the election. By that time, it was too late for the gentleman who thought he was the winner, to request a recount, because he didn't know that information until the Wednesday, the 8 days after Election Day, which unfortunately was past the deadline to request a recount. The winning candidate, she did agree to allow the recount to occur. She did not rescind her request for a recount, and the board granted it, and the results were upheld. However, the intent of this legislation is to give a couple of more days for the tabulation to be completed in order for the winner or the winners to know who the winners are and the losers to know who loses, the trailing candidate. That way they can make the appropriate request for a recount by the deadline, so we don't have a reoccurrence, or we lessen the chance of a reoccurrence of what occurred in the general election. So the staff supports this legislation.
And it's only an additional 2 days, right?
Yes, 2 days.
I was gonna ask, do you think that's enough, or
It's gonna-
Yeah.
it's gonna be-
yeah? Or do you think more
Yes,
days would
we
be
thought it
helpful?
was enough because it gives, it's past the 7 days for military and overseas and deficient ballots. We would certainly need to move up our processing of deficient ballots quicker and have the board meet sooner before the deadline in order to make sure all of those ballots are in the count, and that, that satisfied their concerns about any reoccurrence of what happened. But obviously, the law was written as 7 days, and military and overseas have 7 days, and deficient ballots have 7 days. So it was a confluence of deadlines there, where unfortunately this individual didn't know he was the losing candidate until after the actual deadline for the recounts to be submitted. So
So this brings us to the Thursday after the election?
Thursday after the election, yes.
Yeah, I was gonna say, I wonder if 9 to 10 days. Do you think 10 days would be?
We thought 9, and they agreed with 9. They proposed 9. It was a balance because we do have to run the risk limiting audit as well, and
Oh.
we do need to conduct recounts.
Okay.
So in order to get this done before, and especially in presidential years where we have the president, the electoral college does need to meet, so we were concerned with the Thanksgiving holiday and pushing
Mhm.
into that. So we thought the additional 2 days was sufficient, and we agreed with that. They agreed with that as well.
I'll
Do you have a-
move to support.
And I will second. All in favor?
Aye.
Next bill is House Bill 5470, introduced by Representative Tanzi. And multiple co-sponsors, this act would submit the state's 2026 capital development program requesting the issuance of general obligation bonds totaling $100 million to approval of the electorate at the general election to be held in November 2026, and the staff has no position on this.
Any thoughts? Do you have any thoughts, Lou? Any motions?
I mean, I don't think you should take a position
I
one
agree.
way or the other. so
Yeah.
I'll say no position.
All right, and I will second that. All in favor?
Aye.
The final bill is House Bill 551, no, we have 2 more, sorry, after this. House Bill 5519, introduced by Representative Newberry and multiple co-sponsors. This act would repeal authorizing Rhode Island to join an interstate compact, which would allow presidents and vice presidents to be elected by a national popular vote rather than the electoral college. And the staff has no position on this.
I move that we take no position.
I will second. All in favor?
Aye.
The next bill is House Bill 5520. This bill, introduced by Representative Newberry, would change the manner by which a presidential electoral college electors are elected. It would create a system of grouping municipalities of equal populations, one of each of Rhode Island's electoral votes, with the winner of each group for presidential elections and each group receiving 1 electoral vote. I mean, we looked at this and we're trying to determine if there would be any impact on the way we draw our precincts, or it didn't, it appears only results-based.
Mhm.
This is clearly a policy decision. There are some other states that do something similar where they modify, they stagger how many electoral votes are given depending on the election results. So we don't have any position on that, and we don't believe it will impact any of our results reporting or precinct operations, so.
I'll move to take no position unless we can get some legislation that adds electoral votes.
That's right. Unless we can find 4 more. I'll second that motion. All in favor? Aye.
And the final bill is House Bill 5538. And this is introduced by Representative Cruz and multiple co-sponsors. This act requires the state use actual residences of persons in government custody for redistricting purposes. Information would be collected by the Department of Corrections and forwarded to the Division of Statewide Planning to be utilized for redistricting. The staff has no position on this, other than the fact that it probably would heavily impact, I believe, the city of Cranston. They would probably get more precincts, but they could get more voters because the ACI and multiple state penitentiary facilities are in Cranston. But it wouldn't impact overall the operations or the administration of the election.
Have we ever taken a position on this?
I don't know. I don't believe so. And this has been introduced in
Decades.
several different variations
Yeah.
for a few times.
I'll move that we take no position.
I'll second. All in favor?
Aye.
And that concludes my report to you on legislation submitted so far by other entities. We potentially could have several more in the coming weeks. And at that point, once we get a few, we will reschedule another subcommittee meeting to present those as well.
And then just to clarify, so for our next full board meeting, we will review item 1. We will review those that we could not make a decision of, or those that but the ones that we don't have to go one by one for the rest of them.
Generally, the board has taken, I think, maybe 1 or 2 in the past that the subcommittee did vote to support. The board did take up, but for the most part, the full board would accept the recommendation of the supported bills and then just take up the ones that had no position or or perhaps even, I don't think we had any today, not opposed. Did we have one opposed, I believe?
We had,
We
yeah,
had two opposed, right?
yeah,
So, and perhaps the
did.
two
Yep.
opposed,
Mhm.
so.
Senate 02 and 2.
Two, right?
House
Two.
5.
yeah, two of them, yeah. Mhm. Some of the Sunday ones, yep. Okay. Oh, yeah, we did the verification of licenses. That one was an opposition. Yep, great, okay. Do we have a motion to end the meeting?
Motion to adjourn.
I'll second that. All in favor?
Aye.
Thank you.
Very efficient.
Look at us.
One good thing.